There are some formalities that actually play into asset protection planning. For example, as you are probably aware, corporations are subject to this requirement of having annual meetings of officers and directors and of having to keep minutes of those meetings. You know, and we all have these big red binders where clients keep all of their corporate documents and they insert their minutes. And, you know, quite frankly, how often do most clients keep their minutes? You know, once a year? No. Once every 5 years? Yeah, that's more like it. They'll catch up on all of their minutes and, you know, put them in the book. It's somewhat of a cumbersome requirement, but we can deal with it. You know, it's not the end of the world. But what happens if the client is, you know, the corporation is required to maintain these formalities and it does not? They do not keep the minutes. They do not have the annual meetings. What happens? Well, in the context of a lawsuit against the corporation, the plaintiff can use the lack of minutes as a reason to pierce the corporate veil, to make what's called an alter ego argument. What is piercing the corporate veil? Well, and we'll discuss in a little bit more detail in a few minutes, but basically it's the plaintiff's ability to simply ignore the corporation and to proceed with the lawsuit directly against the shareholders of the corporation, to go after the assets of the shareholders. Obviously, we want to make that exercise a lot more difficult for them, to shield our clients' assets. So with the corporation, you know, the plaintiff can argue that corporate formalities are not being maintained, and therefore the corporate veil should be pierced. If you have a, let's say, a limited liability company or a limited partnership, there is no requirement in any state that the LLC or the limited partnership maintain these annual meetings of you know, members or managers, keeping minutes of those meetings. They can if they want to. You know, it's not forbidden. You can have those meetings and those minutes, but you're not required to. And if you're not required to, if you do not do this, obviously the plaintiff cannot then use this as an argument to pierce the corporate veil of the entity. So from a liability standpoint, an LLC or a limited partnership is better because there's one less argument that the plaintiff can make to set aside the liability protection that these entities afford us. There are certain other you know, issues that play into this economic flexibility of the different entities. For example, in some states we can set up this entity called series LLCs and series limited partnerships, which is in some cases just a wonderful, wonderful planning context. We've been working with series LLCs for the past 10 years, and you can do a lot with them in the right set of circumstances. Well, let's talk about liability protection because it is really our most important subject today. It's our only subject today. How do different entity types play into the liability protection? And I will explain the differences by constructing a little hypothetical for you, so it will be easier for you guys to visualize it and to follow it along. Let us say that our client, Dr. Brown, owns 2 apartment buildings. Let's say that he owns apartment building number 1 through a corporation, and he owns apartment building number 2 through a limited liability company. Okay, so 2 apartment buildings. One owned through a corporation, one through an LLC, and let's say that a tenant in each apartment building slips and falls and files a lawsuit. Who will they file the lawsuit against? Well, in case number 1, they will file the lawsuit against the corporation. Case number 2, they will file the lawsuit against the LLC. And for now, for simplicity, I'm ignoring the lawsuit against the property management company. It has nothing to do with this discussion. Okay? So we have the lawsuit against the corporation and the LLC, and the question is, once that tenant gets a judgment against the corporation, against the LLC, and they reach the assets of those 2 entities, can they now come out of those entities, so to speak, and go after the personal assets of Dr. Brown? What is the general answer? Well, the general answer is no, they cannot. They cannot because under the law of any state, a corporation or an LLC will give Dr. Brown the so-called liability shield. What is this liability shield? Well, it's what we just discussed, that if the corporation is being sued, the liability belongs to the corporation. It has nothing to do with Dr. Brown personally. unless the plaintiff can pierce the veil of the corporation and go after them, Dr. Brown personally. So for example, let us say that I own a share of Microsoft, and tomorrow Microsoft loses a $10 trillion judgment for antitrust violations, whatever. Do I need to worry that that plaintiff is going to come after my personal assets? Obviously not. It's a silly notion. Well, but the rule is the same with any legal entity. You know, Microsoft does not have any sort of special protection because of its size or because it's a public company. Any corporation will provide this liability shield. Why? Because the corporation and the LLC, same rule here, they have their own legal existence, what's called juridical existence. Okay, they're a separate legal person, separate and apart from Dr. Brown. The tenant filed the lawsuit against the corporation, and it's now the liability of the corporation. It's not the liability of Dr. Brown, it's the liability of the corporation. So Dr. Brown's assets have nothing to do with the corporate liability. Dr. Brown's assets have nothing to do with the LLC's liability. Okay? So in each of these cases, the entities gave Dr. Brown the liability protection that he wanted. This is probably the reason why he set up these entities. Well, now, let's change the facts a little bit and make it a little bit more interesting. Let us say that Dr. Brown is driving home from work. He's tired after a whole day of doing surgeries. It's dark outside, it's raining, and all of a sudden he runs over a troop of Girl Scouts. There are cookies all over the place. It's a hypothetical that will stay with you for a while. Now the person being sued is Dr. Brown himself. It's not the corporation being sued, it's not the LLC being sued. Dr. Brown was the one behind the wheel. He is the one being sued. They get a judgment against Dr. Brown, and they get his house, and they get his bank account, and his investment account, and his trophy wife, and his expensive car. And now the question is, can that plaintiff reach the 2 apartment buildings? Well, plaintiff goes to Dr. Brown and says, Dr. Brown, we want apartment building number 1. What does Dr. Brown say? Dr. Brown says, I'd love to give it to you, but guess what? It ain't mine. I do not own it. True? Of course it's true. He does not own this apartment building. The apartment building is owned by the corporation. Okay, the plaintiff says, it's true you do not own this apartment building, but there is something else that you own. What is it? He owns the stock of the corporation. He owns the shares of stock. Can the plaintiff take the shares of stock from Dr. Brown? The answer is yes, they can. The shares of stock in a corporation is a personal asset, like any other personal asset that Dr. Brown owns. And like any other personal asset, they can take it from him. And once the plaintiff gets the shares of stock from Dr. Brown, they are the shareholder of that corporation. They own the corporation that owns apartment building number 1. They are the shareholder. They can vote to liquidate the corporation, sell the underlying asset, and they get the cash. They are the shareholder. So what happened? What happened to this liability protection that the corporation is supposed to give us, that we've all heard about so much? A lot of times people forget that the liability protection of the corporation only applies if the lawsuit is directed against the corporation itself. If the liability of the lawsuit is directed against the corporate shareholder, the corporation will do absolutely nothing to protect its assets. Corporate shares can be taken away from you by the creditor. If I own that same share of Microsoft and I get sued, anyone has any doubt that I will lose that share of Microsoft? Of course not. It's a personal asset. Creditor can take it from me. So Dr. Brown loses the corporation, and Dr. Brown loses the apartment building in the corporation. Now, do we have the same result or a different result with the limited liability company? Well, you get to find that out after the 10-minute break. Okay, and welcome back. You guys are at your desks. We'll resume. If you're not, please get back to your desks and continue listening to the presentation. we were talking